Alright people, so welcome to Jumbo IAS and welcome to UPSC Prelims Phoenix batch. In this batch, we revise the entire syllabus for UPSC Prelims examination, both static as well as current affairs. Now currently we are going on, or we are covering the static portion, and in this static portion, we are covering Indian polity. Now today is day 9 for Indian polity, and our today's topics were, well, Panchayati Raj institutions, urban local bodies, and special administration, or administration of special areas, right? So these are the topics. I'm guessing that you have already gone through the notes because the notes were provided to you well in advance. So you've already gone through the notes and now you are sitting for this lecture. This would be your revision number 2 through a set of 30 MCQs. So let's begin, okay? So Indian polity, day 9, and these were our topics. Panchayati Raj institutions, urban local bodies, and administration of special areas like UTs and other areas like tribal areas and others. Okay, so first we'll cover Panchayati Raj institutions, then urban local bodies, and then special areas. All right, so let's begin with question number 1. With reference to 73rd Constitutional Amendment Act 1992, consider the following statements. It is mandatory for every state in India to constitute panchayat at village, intermediate, and district level. Chairperson of a panchayat at village level must be elected indirectly by and from amongst the elected members. All members of panchayats at village, intermediate, and district levels are elected directly by the people. Now look, you all know that 73rd and 74th Constitutional Amendment Acts introduced local bodies. 73rd Constitutional Amendment Act introduced Panchayati Raj institutions and 74th introduced urban local bodies, right? You all know about this. Now, these amendments gave certain provisions with respect to constitution of local bodies, okay? So 73rd Amendment Act gave certain provisions which all states have to follow. But they left certain provisions open for state legislature. Okay, so certain provisions are compulsory for all states, and some things with respect to constitution of panchayats have been left open to state legislatures as per this constitutional amendment. States will decide on their own what they want to do about it. Okay, so that is why under 73rd Constitutional Amendment Act, there are certain compulsory mandatory provisions and certain voluntary provisions which the states will decide. Now, it is mandatory for every state in India to constitute panchayat at village, intermediate, and district level. It is mandatory only for those states whose population is more than 20 lakhs. For states whose population is less than 20 lakhs, well, they don't have to constitute a panchayat at intermediate level. So this is false because it is written every state. That is not true for every state. Okay. Chairperson of a panchayat at village level must be elected indirectly. No. The constitution says that chairperson of the panchayat at village level will be elected as per a law made by state legislature, and different states have different laws. So this is also false. But yes, this is a compulsory provision that all members of panchayats at village level, intermediate level, district level, all members shall be elected, directly elected by people. This is a compulsory provision. Okay, so 3 only. Make sense? Next. Now you all know various committees were formed with respect to constitution of panchayats. Okay, there were various committees, and then 73rd based on the recommendations of these committees, 73rd Constitutional Amendment Act was passed, right? So one committee was GVK Rao. So GVK Rao committee, while recommending the strengthening of panchayats, expressed concern over which of the following? They expressed concern that panchayats are not that strong. What was their concern? Well, their concern was competition from bureaucracy. They said that because bureaucrats are handling development expenditure, they're basically not giving powers to panchayats. Bureaucratization of development administration as against democratization. State governments prefer bureaucrats. They give more power to bureaucrats rather than elected panchayat officials. This hinders their development. And because of that, GVK Rao committee used this term. It is grass without roots. Generally, we use the term grassroots democracy for panchayats, right? But they played with this word, grass without roots. Their roots are cut by the bureaucrats, state governments, officials. So currently the core problem was B. Okay, next. Consider the following statements regarding disqualification of members of panchayat. A person is disqualified from contesting if they have not attained the age of 25. No, 25 is for an MLA. For panchayats or municipalities, urban local bodies, the minimum age is 21. You just have to be 21 years of age to fight elections. Okay, so this is false. All questions of disqualification shall be referred to such authority as determined by state legislature. This part is definitely correct. Okay. If there is any question, dispute with respect to disqualification, well, it shall be resolved as per a law made by state legislature. A person can be disqualified if they are so disqualified under any law made by state legislature. Absolutely correct. Okay. B. Next. Which of the following areas are exempted from application of 73rd Constitutional Amendment Act? You know, 73rd Constitutional Amendment Act is not applied across India. There are certain exceptions. There are certain tribal areas which have their own local customs. So 73rd Constitutional Amendment Act does not apply over there. Nagaland, Meghalaya, Mizoram, hill areas of Manipur where district councils are already there, Darjeeling, Gorkha Hill Council, scheduled areas and tribal areas as defined under 5th and 6th schedule. All PRIs or 73rd Amendment does not apply to these areas because these areas already have their own system of local governance, okay, and they have their own tribal customs and all. So D. Remember this, all these things, okay. These are the exceptions to 73rd Amendment Act. Next. Regarding the State Finance Commission, consider the following statements. The governor of a state shall constitute a State Finance Commission every 5 years. State Finance Commission makes recommendations to governor regarding the distribution of net proceeds of taxes between state and panchayats. Central Finance Commission suggests measures to augment consolidated fund of state based on recommendations of State Finance Commission. Now look, there is a Union Finance Commission whose job is to recommend to the central government how much money should be distributed with the states. Okay, so central government collects money based on various taxes. Some of that money is shared with the states. How much? Well, that how much is decided by Union Finance Commission. Similarly, states also have to share money with Panchayati Raj institutions and urban local bodies. Now, how much? States also collect some money through taxes. How much of that money should be given to these institutions, local bodies? Well, that recommendation, that is done based on the recommendation of State Finance Commission. Now, like Union Finance Commission is appointed by the President, State Finance Commission is appointed by the Governor. Okay, for 5 years, yes. State Finance Commission makes recommendations to the Governor regarding the distribution of net proceeds of taxes between state and panchayats, yes. Central Finance Commission suggests measures, yes. Union Finance Commission also suggests measures as to how much money center will give to states so that they can give to panchayats. So apart from this distribution, there is an extra distribution by center. Yes, all are correct. Okay, next. Which of the following is a voluntary? Remember, I told you there are certain compulsory provisions, there are certain voluntary, up to the states. Why voluntary? Because local bodies is part of state list. You remember there are 3 lists. Union list, state list, concurrent list. Local bodies is part of state list. So states have been given this freedom apart from certain compulsory provisions. Now, what are those voluntary provisions? Organization of Gram Sabha in village or group of villages. Giving representations to MPs and MLAs in different levels of panchayats. Now, Gram Sabha is a compulsory provision. Every village should have a Gram Sabha. This is not voluntary. This is voluntary. Okay, states will decide whether they want to give some representation to MPs and MLAs of that area in that panchayat. That will be up to the state. Reservation of state SCs and STs is compulsory. Direct election is compulsory. Okay, people will be elected directly by, members of panchayats would be elected directly by people at all levels. This is a compulsory provision. So voluntary is only B. Okay, next. Under the PESA Act 1996, which of the following powers are specifically attributed to Gram Sabhas in scheduled areas? Now remember, I told you that there are exceptions to 73rd. Scheduled areas and tribal areas, right? For scheduled areas, well, the parliament created a separate law called PESA. Okay, so that there are panchayats over there. Panchayati Raj Extension to Scheduled Areas Act. Okay, through this law, Panchayati Raj system is extended to scheduled areas. But under this extension, certain changes were made to 73rd Amendment Act. Okay, now some of those changes were related to Gram Sabhas. Gram Sabhas were made extra powerful in scheduled areas. Now, what are their powers? Okay, Management of minor forest produce, yes. Consultation on matters related to land acquisition. Whenever there is going to be land acquisition in your panchayats, okay, gram sabhas should be consulted. Compulsory reservation of all chairperson seats for women, no, there is no such thing. Women reservation can be there, but there is no compulsory reservation. Recognition of customary methods of dispute resolution. Look, tribals have their own customs with respect to dispute resolution. That would be honored, and gram sabhas would handle that. Okay, so 1, 2 and 4. All right, next. Remember, there were many committees. One was Ashok Mehta committee. So consider the recommendations of Ashok Mehta committee. Which of the following were proposed by it? Replacement of 3-tier panchayat system, that is village panchayat, intermediate and district, with 2-tier system consisting of Zilla Parishad, district panchayat, Mandal panchayat, that is intermediate, no village level. Yes, Ashok Mehta said that. Official participation of political parties at all levels of panchayat elections, yes, because Ashok Mehta believed that if political parties who are in power at different parts of different areas of government, center and states, well, if political parties are participating in panchayat elections, panchayats would get more recognition. They would be more powerful. Yes. State government should not supersede PRIs. If they do, elections must be held within 6 months. State governments should not dissolve panchayats, and if they do 6 months, they have to elect a new one. Seats for SCs and STs should be reserved based on their population. Yes, all. Okay, next. With reference to 11th schedule of Indian Constitution, which of the following subjects are included in the list of 29 matters? Now look, when 73rd Constitutional Amendment Act was added or passed, well, they said that we are now making panchayats through this. Now, panchayats should be strengthened. Panchayats should be given powers. Now, what powers can you give to panchayats? Those powers are mentioned in 11th schedule of the Constitution. Okay? 11th schedule of the Constitution contains 29 matters. These are those powers that can be given to Panchayati Raj institutions. Now, remember, the important word is can, which means how many of these 29 matters would be given to panchayats? That depends on the state. Certain states like Kerala have transferred all 29 matters to panchayats. Certain states have only transferred 2, 3. So it is up to the state. Now, what all is mentioned in these 11th schedule? Minor irrigation and water management, yes. Small scale industries including food processing, yes. Public distribution system, yes. Technical training and vocational education, Kaushal Vikas Yojana, yes. Land reforms. Now, here's the thing. Land reforms can be implemented by panchayats, but they won't be conducted by panchayats. They would be conducted by state only. Land reforms is the domain of states. The implementation part can be done by panchayats, but it is the state's job. So it is not mentioned in 11th schedule. So 1, 2, 3, 4. Okay. Next. Regarding the State Election Commission, consider the following statements. State Election Commissioner is appointed by the governor of the state. Conditions of service and tenure of office of commissioners are determined by state legislature. Commissioners can be removed from office in the manner prescribed for the removal of judge of a state high court. Okay. So State Election Commission, well, their job is to conduct elections for Panchayati Raj institutions and urban local bodies. That is their job, right? Now, State Election Commissioner, like Election Commission of India, Election Commissioner of India is appointed by President. State Election Commissioner is appointed by Governor. Now, their conditions of service, tenure of office shall be determined by Governor, not state legislature, not by law. Okay. Now, yes, this part is correct. You cannot remove a state election commissioner except in the same manner as a judge of a high court. And a judge of a high court is removed in the same manner as judge of a Supreme Court. It's very difficult. Parliament can remove state election commissioner. Basically, that's what they are trying to say. And this is correct. B. Okay. Next. With